Welcome to r/Credit by Haunted TTS. Subscribe and like this video for more, and don't forget to click that bell button for notifications. Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you, and what happened? I had a hearing where the opposing party offered an updated contract that my client supposedly signed, except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old contract, except for the party name at the top. The original contract was in his mom's name, the new one in his name, and the date of the contract itself. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that's a serious accusation. I held up the guy's prior conviction for contract fraud and said I absolutely am, Your Honor. We won. Hands down. No further argument needed. My dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the pie due to de facto marriage. Our claim was that she was a gold-digging woman who planned it from the beginning. She had mountains of evidence of her contribution to Dad's company and running the private estate. Expense reports, receipts, dates, and times her and Dad proved their relationship with trips and combined spending, etc. etc. She had so much evidence, the judge took 4 days to look it all over, after which he came back and basically said, "Why the hell would you have all of this if this wasn't your plan the whole time?" The case was very downhill from there. I had a misdemeanor possession case I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console. In a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullshit, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments, the DA says this case is a circumstantial evidence case. During my closing, I slap the jury instruction on the projector that says if a case is based on circumstantial evidence and there is one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. Not a lawyer, but was taken to court once. The guy had taken my family to court, basically he had been dating my mother and things ended. So he then takes us to small claims court with an itemized list of everything he'd ever bought the entire family. Every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible and ruined other things. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now, he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had and would always talk about his connections and would name drop someone anytime we went anywhere. So when he takes us to court with his full itemized list, the judge asks him to go first and present his testimony. He basically says, "Well, I was with them, I bought all this stuff. I took them to dinner all the time and all this, but it was the idea it would be paid back by them." Did you bought a child a birthday cake with the idea it would be paid back? Did you ever say that these things were loans and not gifts? Then well, no, but I shouldn't need to, that's the normal way people think. Judge, well, that's not the way I'd think. Case dismissed. I had to go to court over a financial cock-up when I was a student. Took advice from the university legal support team who said I didn't need a solicitor, so I went in alone. The judge didn't like this and postponed it for another date so I could prove I'd had more counsel first. The other party's solicitor caught me outside the court and said I didn't tell you this and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation that it was right, went to the second hearing alone, and got the entire thing thrown out. The other solicitor winked at me as he left. Saved me about £9K, nice chap. Not a lawyer, but a relative of a retired prosecutor. Relative was working misdemeanor criminal court. Cases get called in alphabetical order, and 2 women named Catherine Smith and Catherine Smith were scheduled to have their hearings before the judge. Not their actual names, but you get the point. Both had similar crimes, but slightly different. So the bailiff announces the next case to the courtroom, Catherine Smith, for 1 count of possession of cocaine with the intention to sell, and 1 count of prostitution. So Catherine Smith stands up and indignantly cries, "Whoa, just wait a second. Where the hell did the prostitution charge come from? I may deal crack." The easiest drug dealing case my relative ever prosecuted. Actual lawyer here. From the fool for a client file. Was interning at legal services after 1L, doing discovery work for family law. My supervisor invited us to observe a hearing for our client to get a restraining order against her husband. At the hearing, the client discussed various times he threatened her. The man, representing himself, interrupted and said, "Judge, I never said any of those things. If I had, she wouldn't be standing here." Restraining order granted. Not a lawyer, but here's a story from the burbs. My buddy is in the middle of a situation like that right now. His psycho neighbor built a wall too high and doesn't have proper drainage on his property for the very small creek natural drainage in between their yards. My buddy hired an attorney as the psycho decided to sue him over it. My buddy's engineer that looked over the property noted, not only did my buddy set his yard up right, but the neighbor created drainage problems. Neighbor hired his own engineer that proved my buddy was correct. Now the guy is likely to go postal. Case was going to go to mediation. Since both engineers found fault with the psycho neighbor, my buddy decided he's going to take it to trial. Turned the tables a bit. My favorite is a story from Jerry Spence. For those who don't know, he is a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asks the witness to demonstrate to the jury how far he could lift up his arm before the accident. He lifts his arm much higher. The jury laughs. The case is over. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual, but the defense didn't study their chemistry very well and kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry, did you mean carbon monoxide? Because that's a completely different thing." Completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel screwed himself by not picking up a book. I worked as an intern for a lawyer. Construction law, in France, are quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the house of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360 degrees picture from said bell tower. We, as kindly, pointed to them that our client's house was, indeed, not visible from the top of the church. Building permit was greenlit the following day. Actual lawyer here, and this one was especially sweet. Was involved in an ownership control dispute of a Venezuelan company. Well, we had no doubt who controlled the company. Opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work and how they are in effect the highest law of the land, which meant the case should be over and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company, but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order. The guy I used to work with was going through a messy divorce, about 20 years ago now. His soon-to-be ex-wife was a psycho, and her father was a psychologist, so he was pulling all of the strings. He even had my co-worker arrested at work one day, BS charges. The divorce case took years, one young son involved, and at every turn, my friend lost because of something the father filed or another string he pulled. In the end, they were in court, and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was squashed and he was mentally broken. The judge asked the ex-wife if she had anything else to add, and she said she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case, and she said yes. The judge turned to my friend and said, paraphrasing, "Mr.XXXXXXX, all these years and all these claims that I ruled against you, the court profusely apologizes. I did not believe you, but now I do. Ruling in your favor, bangs the gavel, I grant you full legal and physical custody of your minor child. Bailiff, please handcuff Miss XXXXXXX." My buddy was stunned that he won and happy at the same time. He later found out that the note said, "Give me my son, or I'll kill you." Not a lawyer, I know, but my parents were in a lawsuit where this happened. They owned a business, and on the either side of it were businesses as well. Their neighbor to the left sued us, claiming that we had been using their property without paying them or without permission. That we were essentially trying to adverse possess it. We got a surveyor to come in, and the surveyor said that not only were we using all of our property, but we had been paying rent to them on about 20 feet that was also our property. Obviously they weren't happy, so they got their own surveyor. Who gave us 50 feet, we won the lawsuit. Now their little patch of property has a rusty fence all around it with keep out signs everywhere. It's about 20 x 10 feet. When I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel. Basically saying that the old lawyer didn't do his job. So we prepare an argument based on not asking the right questions, not communicating, etc. We think it's going to be a tough case, but not unwinnable. Then we get the response to our complaint, where the old lawyer argues that he was only ineffective because he didn't have time to prepare for the case and only reviewed it the morning of the original trial. He had known about the case for months, by the way. The judge saw this, and during the trial we had essentially asked, isn't this the definition of ineffective counsel? Not giving enough time to your client. The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer than that. Thanks opposing counsel. I guess you were ineffective for both of you. Boo, I've got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they were not part of our yard, the tree was owned by my parents and they were responsible for it. Some guy tripped over a branch and was seriously injured. He came after my parents for all of the money. The dude showed up with a mountain of evidence. Hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently, his lawyer brandished this stuff like a bat before court. My parents' lawyer thought he had a good case. Until the first day of court, when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief. "No, that's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, a completely different tree. At that point, the opposing counsel whirled around and started screaming at his client who said that was their tree. Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All's well that ends well. Accidentally proved. Not often. Made tactical errors. Often. Arguing a case on a voter account in front of a judge. Judge says, "I'm going with X. That's in my favor, so I shut up." Opposing counsel, in arguing a different point later, suddenly goes back to the earlier point and belabors it. Client, also a lawyer, says to me, "Don't say anything." I whisper back, "Don't worry, wasn't planning to." Judge begins rubbing his nose and looking irritated. After a few mins, cuts off opposing counsel, saying I already ruled on this point. Mr. Smith me, anything to add? I replied in the negative and won my motion. Would it have come out differently? I don't know. Did opposing counsel make it easier for me? Absolutely. My opposing counsel made some off-the-cuff remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or the records-keeping process. In the jurisdiction we were in, records were exception to hearsay rule, but you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness's qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records and won. All because the opposing counsel complained that their witnesses had to go way out of their way to get records for the court. Domestic violence case where the husband beat the wife senseless. Landlord tried to evict wife for breach of lease due to the beating. Landlord claimed wife violated lease terms by allowing police to be called to property and causing a disruption. My argument was that as a domestic violence victim, wife is covered under VAWA and the property is HUD subsidized. Also MD law offers DV protections too. Landlord's counsel during his opening talked about how my client was beaten and the police were called and an ambulance etc. I just stood there looking at him. When he finished, judge asked if I had anything to say. My response, "No, Your Honor, I believe opposing counsel has said everything that needs to be said." Judge smiled and ruled in my client's favor. Landlord can't evict DV victim.